Next, we have Azam Nizamuddin, who's an attorney and general counsel of the American Trust Corporation, North American Islamic Trust, who will speak about religious arbitration in mosque disputes.
Good afternoon, everyone. I'd like to thank Professor Bombach for convening this conference and to the other organizers and my fellow panelists as well. My paper encompasses both the issues involving mediation and arbitration in the mosques and institutional context, but also some in family law as well, because there's been a growing sort of development in that particular arena of family law disputes. Now, private alternative dispute resolution has been going on in the Muslim community really since the inception of Islamic civilization. The Muslim community, both scripturally, but also from a state perspective and a civilizational perspective, has encouraged disputes to be resolved outside of formal litigation. And these were historically and even contemporaneously known as tahkim, which is arbitration, sulh or wasata, mediation. Now, this dispute process actually had been formalized historically into what's known as Islamic law or Sharia. And specifically, the concept of tahkim are found in the Quran, particularly chapter 4, verses 35 and 58, specifically a verse that says, if you anticipate a split between a couple or a party, appoint a mediator from one member of the family to another. And if they desire reconciliation, God will restore harmony between them. Furthermore, indeed, verse 58 says, indeed, Allah commands you to return trust to their rightful owners. And when you judge between people, judge with fairness and nobility. So the operative words here is فَبْعَثُوا حَكَمًا مِنْ أَهْلِهِ, as well as وَإِذَا حَكَمَتُمْ بَيْنَهَا. So hakim, the role of hakim, which later on becomes formalized into different roles within the state hierarchies, judge or mediator. In addition to the Quranic basis, there's of course the example of the Prophet Muhammad, particularly in his role as a community leader in Medina after the Hijrah movement. You have him really specifically not only mediating disputes within the Muslim community, but also between the different Jewish tribes and the Christian community as well. And that legacy lends itself to a historical precedent for providing these types of ADR resolutions. And you see this again formalized in different as Islamic law treatises in different communities over a millennium. Specifically, my paper addresses what's happening here in the United States with the rise of particularly the immigrant and Muslim community since the 60s and 70s, where you begin to see both institutional disputes as well as family law disputes. And I can tell you, as someone who has litigated mosque disputes and divorce cases, I'd be happy to deal with a divorce case any day over mosque disputes. Mosque disputes can be extremely contentious, very personal, and they can last a very long time. And as a result, historically, what would happen is typically you'd have an elder in the community or a scholar or an alim who would be assigned to help mediate a dispute between different factions that go on. And historically, it was completely based upon a person's reputation, standing, and even I would say charisma in the community. And that was what happened in the 70s and 80s up until the 90s. But as you begin to see more institutions growing, the institutions becoming more sophisticated, and of course, the growth of lawyers in the Muslim community, you find that this role of the arbitrator in an informal sense, based upon the religious standing, reputation, and charisma really could no longer function. And therefore, you begin to see a more recent attempt by attorneys to try to formulate a process to try to either adjudicate in terms of mediation or arbitration. In fact, this has become more so because of the fact that informal mediations and arbitrations that were actually done and were even formalized into an agreement of resolution were challenged in courts. And there's a famous case both in Indiana, in which an attempt by various members of institutions conducted a mediation arbitration and ultimately led to a written agreement, which was challenged in court and ultimately held unenforceable. A similar occasion occurred in a community dispute in Rochester, Minnesota, which ultimately was upheld because they really took pains to formalize everything with notice, et cetera, and due process and so forth. A famous case in Illinois, which actually went to the appellate court, involved an imam, which served as an mediator, arbitrator of a divorce dispute between a couple. And this imam basically took on the role of judge and jury and decided that he would take on the role of determining whether to grant parenting rights or custody to the couple based on his own determination, not on the facts on the ground, not in the best interest of the children, for example, which is the standard in most states. And as a result, that decision by the imam led to an appeal which overturned the entire divorce case in Illinois. And as a result of these kinds of examples, you're beginning to see now more of this formalized ADR approaches in the Muslim community. And really going forward, what's going to be needed is more training for people involved in ADR procedures, whether they're informal or formal, and understanding the law, whether it's contracts, whether it's not-for-profit law, or if it's the law of family law. Having more credibility in terms of an organization's ability to engage in fair, open, transparent, and due process procedures put into place to make sure that it achieves the goals and success for this process.
Thank you so much. Sorry.